Hi guys. I wasn't going to do this next, but some important decisions came from the Supreme Court today that I wanted to share with you. So I've still got more Dan coming, more Dan emails. I've got the deal with the devil coming, and I just wanted to pop this in there because there's some misinformation going on around about one of these decisions. If you don't know, my name is Spirit. I was a pharmacist for over 30 years and I worked for the government for 13 years. In my capacity with the government, I had the opportunity to interpret and actually draft laws for the state of Florida, which were also picked up and submitted by federal agents that I worked with for federal laws. So I had a lot of opportunity to read these things and I began to understand them. Okay, so today, June 25th, 2026, the Supreme Court ruled on 4 different cases. And in my opinion, it was really a great win for Americans. And there's going to be another one coming out, I hope, next week. So let's take a look at these decisions. First was Mullins versus Doe, which is a case about immigration temporary protected status. Okay, so TPS, Temporary Protected Status, was created by Congress in the Immigration Act of 1990. Initially, the periods were only supposed to be 6 to 18 months, but they could be extended and redesignated repeatedly if the condition continued or persisted. And of course, lots of them stayed here. So TPS didn't give them a direct path to citizenship or any kind of legal residency, but they could apply if they chose to and met the criteria. Millions chose not to and just continued to stay here. Once designated as TPS, these people can apply for multiple benefits, and guess who pays for them? We do. It was never intended to be a permanent thing, but as with so many of our laws, people found ways to abuse them. The reasons that people could apply for temporary protection status was if there was an ongoing conflict, armed conflict or war that posed a serious threat to their personal safety if they returned home. And Afghanistan might be an example of that. Another reason would be an environmental disaster that might occur and provide substantial disruption of living conditions. That was Haiti. Then there's one under extraordinary temporary conditions that prevent their safe return. And of course, lots used that one, that I can't go home, I'm afraid, the gangs, blah, 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 all that stuff. So what happens is the DH secretary reviews the country conditions periodically, at least 60 days before the expiration date of their TPS, of when that country was determined to be eligible for TPS. And then the secretary is supposed to decide to extend, redesignate, or terminate that status. Well, before Trump got in office, there was Alexander Mayorkas, and I'm not going to say any more about that. So SCOTUS just decided that courts have limited ability to review these terminations, because what was happening is these people were going to court and saying, that's not fair, I want to keep my TPS and all this stuff. Well, hundreds of thousands of people from countries like Haiti, Syria, Venezuela, El Salvador, Ukraine, and others have held TPS status in the recent years. The Trump administration moved to terminate many designations, but has hit numerous roadblocks by lower liberal courts on cases brought by the illegal foreign nationals. What a shock, huh? So today, SCOTUS upheld that the president has broad executive authority to end these statuses, and the courts can't stop them. In a 6-3 conservative majority decision, the court ruled that the president has broad, legal, largely unreviewable authority to terminate TPS designations. And this now allows the Trump administration to proceed with ending temporary status protections for hundreds of thousands of long-term residents who were here legally under the TPS status from countries like Haiti and Syria, potentially leading to many more mass deportations. Now here's the odd thing. The plaintiffs were a group of Syrian and Haitian nationals. So these people are here in our country suing our government. Generally, foreign nationals don't have the right to sue our government unless they're in the country. So once they get here, or the other reason is if they were damaged, if they can prove that they were damaged, then they can, even if they aren't in the country, foreigners can sue us. So that was a big win, in my opinion, that now we can, all these people that have been sitting here illegally, or legally under temporary protective status, they're now going to be deported. And the courts can't do a thing about stopping President Trump. And the next one was a case called, that was the first case. The second case also deals with immigration. And that case was Mullen versus Al Otro Lotto. And that was another 6-3 reversal. The court held that asylum seekers who were stopped at or on the Mexican side of the border have not yet arrived in the United States under the Immigration and Nationality Act. This sided with the government in a border dispute which limited asylum processing rights for those who were turned back at the border. Of course, the dissenters were Sotomayor, Kagan, and Jackson, and the plaintiffs are a California nonprofit legal service, nonprofit and other NGO guys, that assisted these migrants and refugees when they were coming into the U.S. and Mexico. You've seen them. That company is Al Otro Lotto. And you know those companies. They're a bunch of lawyers that, make money on these immigrants and fighting our government to let them in. Now, they joined with with 13 asylum-seeking foreigners who were from Honduras, Mexico, Guatemala, and El Salvador. Again, now these people were turned back at the border. So even though they aren't in the United States, they were allowed to sue us because they're claiming they were damaged by it. Between 2012, so we're talking Obama, right, to 2021, the U.S. granted asylum to over 46,000 people from Guatemala, Honduras, and El Salvador combined. The Mullen versus Doe ruling on the temporary status case will have no effect on those 46,000 people who have been granted asylum. So we're stuck with those 46,000 unless POTUS can figure another way to get them out. Then there was a big Second Amendment win, guys. The case was called Wolford versus Lopez. And again, in another 6-3 divided down party lines decision, the Supreme Court struck down a Hawaii law requiring gun owners to obtain permission from people that owned public properties on private land. So let's say you have a business. They were trying to pass a law that anybody that walked into your business had to disclose that they were carrying a firearm before they could come in. And that was struck down. Those were open to the public and they couldn't discriminate against those people. Then the big one. Here's the confusion, guys. It was Monsanto versus Durnell. And this one is one that you're going to hear a lot of on the social media channels. And there's going to be a lot of POTUS bashing about it from both conservative and liberals, is what I'm seeing. But if they took the time to research the case, they would understand that the ruling in favor of Monsanto's was a correct decision. This particular one was a 7-2 decision, and it was not split across party lines. Justice Ketanji Brown Jackson and Justice Neil Gorsuch dissented. The court held that the Federal Insecticide, Fungicide, and Rodenticide Act, known as FIRFRA, expressly preempts state law failure to warn claims against Monsanto for Roundup labels. So the people were saying, look, I got cancer, and they should have notified me. They should have had a claim like cigarettes. This could cause cancer or be hazardous to your health. Sounds like that would be a winning case, doesn't it? But here's the problem. And this decision now shields Monsanto from cancer-related lawsuits where the EPA has not required a warning. This basically reverses lower court wins for plaintiffs. For this particular plaintiff, who was supposed to get compensated, the court ruled that he would be compensated, and now SCOTUS has overturned that. Now here's the problem. The EPA has repeatedly reviewed glyphosate, which is Roundup's active ingredient. And EPA concluded that it's not carcinogenic when it's used as directed. It has approved and reapproved Roundup's labels without a cancer warning. Just as with the FDA, they never considered the cumulative effect of repeated use of these products or the cross-accumulation of toxins that are in thousands of products which we consume every day. So it's the same toxins. And yes, that one little bottle, whatever it is, if you drink it once in that container, it's not likely cancerous. But if you consume it every day in thousands of products or hundreds or tens, if you consume it in so many different products, then the dynamics change and the data changes. So here is why the plaintiff injured party lost. Because federal law requires Monsanto's to use the exact EPA approved label. Same with the FDA. So if those agencies approve that label, they will be fined or other actions taken if they violate the approved label. So the EPA approved it without a cancer warning, and Monsanto was bound not to put that warning label on there, even if they wanted to, which we know they don't. So Monsanto's and Bayer has already resolved roughly 100,000 claims through prior settlements that totaled about $11 billion. But those agreements that they made stand, and this is not going to affect anybody that's already received settlements. But this decision will likely lead to the dismissal of many similar pending failure to warn claims. Now, it's important that doesn't prohibit people from suing Monsanto, only by saying, yes, Wolfie, only they can't sue them because they should have claimed that it caused cancer on the label. So the company has faced and settled massive liability in other cases, and a proposed class settlement is even in the works. People who already settled, like I said, they don't have to pay back the money. So in my opinion, it's the EPA's fault. And here's the problem. They have sovereign immunity. Just like all federal agencies, they can't be sued for their decision. And that is, I hope, going to stimulate Congress to eliminate sovereign immunity for regulatory agencies only. I'm not talking about street cops that go and try and help somebody and then they're sued, and when they try and do something, in goodwill. I'm talking about these agencies only that are making the decisions that affect the quality of our life. They should not be assumed, and they should not be assumed to be immune, and they should be held responsible for the decisions that they make. That will stop a lot of this money going into their pockets for decisions that are not in our best interest. Now, there's one more case that really is a biggie that's before the Supreme Court that they didn't rule on today, and that is birthright citizenship. And this one is a major hornet's nest. And I'm just going to give you my opinion on this, okay? To me, those people whose parents came over and, while they were pregnant, almost always for the purpose of getting birthright citizenship, those children had no intent to violate the law. Their parents did. So in my opinion, if they are adults, 18 years or older, they should be given the right to apply, just like everybody else can apply, for citizenship. And if they meet the standards, if they're not criminals, and they meet all of the scrutiny of our immigration system, then I think they should be granted it. And here's why. These people over 18, some of them have been here their whole life, and they've established connections here. This is all they know, is the United States. If you move those people to a foreign country, they basically have no support systems there because all of their friends are here. Their employment, their property, their investments, whatever, they're all in the United States. So I don't think those people should be kicked out. But if they are minors, I think they should be shipped back with the parents that violated the law. Just my opinion. IMHO. Okay? So it's just my opinion, and we're hoping that that opinion comes out on Monday, but we don't know. Okay, then, this is not a SCOTUS decision, but it's a good thing, and I wanted you guys to hear this. The voting machine people have sued the heck out of Mike Lindell and his company, MyPillow. So I'm a big supporter. I bought a lot of his linens when this all went down to support him, and they're great. They're thick, they're nice, you know, and I'm totally about supporting MyPillow. But after the 2020 election, you may remember that Lindell posted all over social media that Dominion voting systems rigged the 2020 election to steal it from POTUS. He even did a documentary called Absolute Proof in February of 2021. I saw the movie, and in my opinion, what he presented was absolute proof. Of course, it needs to go through the rigors of the court systems and so forth, but the movie was suppressed and widely rebuked by all the usual suspects. That same year, after that movie came out, Dominion filed a $1.3 billion defamation suit against Lindell personally and against his company, MyPillow, in a federal court in Washington, D.C. Of course, Dominion denied that it interfered with the election and was switching votes, and they claimed that it damaged their business and their reputation. Defamation lawsuits like this require the plaintiff who's suing him, Dominion, to prove that the statements were false, published to others, and caused them real harm. They had to show actual malice on Lindell's part, that he knew the claims were false and he recklessly discarded the truth. So, in the last 2 days, Dominion dropped the entire $1.3 billion lawsuit, but the court went even further. It dismissed the case with prejudice, meaning that it's permanently barred from coming back and being refiled to sue him again. So that is a big win, in my opinion. The suit was resolved through a confidential settlement. Both sides agreed to pay their own legal fees and costs, but there's been no disclosure whether Dominion had to pay Lindell or vice versa. So that part remains quiet still. But here, listen to this one. Dominion is now called Liberty Vote. It was sold last year in October 2025 to a former Republican election director in St. Louis, Missouri named Scott Leindecker. Now, this guy founded NoLink in 2011, which became the nation's largest provider of electronic voter check-in systems. Then he purchased Dominion. So personally, I think the government needs to pour through this guy's background and his records to see where his true allegiance lies. I want you guys to know that just because somebody's Republican doesn't mean that they have clean hands. There's lots and lots of rhinos, okay? And there's ones that swing wherever the power is, like some that I've seen. I'm not going to name names here because I don't want my own defamation lawsuit. So, Liberty Vote continues to provide and support the same exact voting systems and machines in 27 states. So this was no way a folding of the Dominion or its machines. It was a rebranding. The hardware, the software, and the existing contracts all transferred to the new owner of Dominion, Liberty Vote. Don't you love the names they come up with? So there's been some attempts to sue them, but there's currently no active lawsuits directing Liberty Vote to have any kind of widespread removal or decertification at this point. Nothing's been filed. The company is active and it's seeking federal certification for newer systems now that they're going to call Frontier 1.0. And so, and they will retire the old hardware, and heaven knows what kind of backdoors or changes they want to make with this new one, possibly to avoid scrutiny of the government. Some states failed to renew their contracts, but as I said, 27 states are currently still using the Liberty Vote, aka Dominion systems. These states include states such as Georgia, Pennsylvania, Michigan, California, Colorado, New York, Puerto Rico, and many others. And the fact is that approximately 1/3 of the country's voters are still voting on these machines. The systems are in place for the upcoming 2026 elections right now. Mike is a true patriot, and he's been subject to so many lawsuits for his claims about the 2020 election. In 2025, a jury in Colorado, liberal Colorado, ordered him to pay $2.3 million to a guy named Eric Coomer, who was a former Dominion employee, for defamatory statements accusing him of treason and rigging the election. That verdict remains upheld so far. There's also similar suits against him by Smartmatic. Remember the other company, Smartmatic? And others have had mixed results with litigation on Lindell. So they're really hitting him hard. If you like the work and the research that I do, I implore you to please like, subscribe to my channel because there's so much more to come. When you ring that bell, be sure to take off the default in the second position and move it to all, or YouTube will decide which of my videos they want to notify you about. If you want to see all of them and you want to have the choice to decide whether you want to look at my videos or not, click all under that button. Leave your comments and thoughts. It's very important because I rely on you guys and I want to know what you think and how you want me to proceed with the stuff that I research. And I'm always happy to look into things if you have certain topics you want to discuss. And here's the thing, guys. Share to as many of your social media platforms as you can. Share these videos because that's how we grow. That's going to bring us new people because YouTube is suppressing the channel and demonetized it right now. I'm working real hard to get back in that so I can have the resources to keep this channel going for a very, very long time. So share. Let's bring other people, let's awaken them, and let them know what's going on from a true, and I can't say I'm not biased, I really can't, but what I can say is that I'm cautious. I don't follow anything 100%. I support POTUS 100% at this point. Maybe not every single decision, but the way I look at it is I don't know everything. There's people that know a lot more than me as far as an intelligence standpoint, and I don't mean up here. I mean information that they have that I don't know about. So I don't judge the decisions that are being made by POTUS. So I try to be as comprehensive, as diligent, and as ethical as I possibly can in reviewing and producing the content that I do. I can't say this for a lot of other people. So I love you guys. Dan, the next one on Dan is going to be our communications about med beds, which is actually how I first met Dan. It was in regard to some of my videos that I did on med beds. So that's coming. Clean Living channel next will be toxic oils that are in so much of our food and why they are toxic. You know, I always explain why I don't expect you to take anything I say at face value. So that's coming. Dan's video is coming. On this channel, there'll be another one, which I think will probably be the deal with the devil, because I've been working on that for a while. I also have in my notepad here the Philadelphia experience, because Vi and another person asked for that. Mac has discussed holographics for healing, which I've done before based on information that Jen Han shared with Dan. And so I will be remastering that one and updating it. And I'll probably include, if I can find them, the emails from Dan about how we use holographics for healing. And then, you know, Mac, I'm torn about this one, but Mac loves Don Jr. and thinks he's going to bring us disclosure. I have my own opinions about Don Jr. And let's say the women he's decided to share his bed with. That's where my concern with Don is. And he's also asked about David Grush, which I don't have enough intel on, and unfortunately I can't reach Dan anymore. So I don't know about that one, Mac, but I'll do my best as always, as you know. So that's it, guys. I love you all. I'm so thankful for every single one of you, and I live in gratitude, and my life has become so full and full of purpose because of each and every one of you. Thank you. Keep me in your heart because I keep you in mine every single day. I love you. Bye-bye, guys. Till next time. Oh, tomorrow. We've got 4 p.m. We've got a live Q&A. I'm not going to prepare for it like I did the last one. Oh, I didn't really prepare. I just ran some news that I was blabbing until we got enough people on there. But I got kicked off somehow. That we lost the stream. And you know, I'll do those things in different. I'll just talk with you while we're waiting for enough people, and they can always go back and review it if they weren't there right off the bat. So don't worry. But we've got a live Friday tomorrow, 4 p.m. and I hope to see every single one of you there. Love you. Bye bye, guys.